10 guns you can legally get without a background check. Here's something most people get completely wrong about firearms in America. They think every single gun transaction involves a mountain of paperwork, a federal background check, and some dealer breathing down your neck while you fill out forms. That's not how it works, not even close. The ATF itself has carved out entire categories of guns that don't even qualify as firearms under federal law. And when you hear what made that list, you're going to rethink everything you thought you knew about gun regulations in this country. Today we're breaking down 10 guns you can legally get your hands on without a background check. No federal firearms license required, no stack of forms, just straight up lawful under federal statute. And I promise you at least a couple of these are going to catch you off guard. Before we get rolling, if you find this kind of content valuable, go ahead and subscribe and hit that notification bell. It costs you nothing, but it keeps this content coming, and trust me, we've got a lot more of this to cover. All right, let's get into it. Let's start with the one that blows the most minds. Under federal law, any firearm manufactured in or before 1898 is classified as an antique. And here's the kicker. Antiques are explicitly excluded from the Gun Control Act's definition of a firearm. That's not a loophole. That's not a gray area. That is written directly into the statute. The law also extends this exclusion to certain replicas and muzzleloaders that either aren't designed to accept fixed ammunition or that chamber cartridges no longer commercially manufactured and not readily available through ordinary channels. What does that mean in practice? It means a federally licensed dealer doesn't run a background check when transferring an antique. The feds simply don't treat these the same way they treat modern guns in that regulatory context. Now, let me put a couple things on your radar before you get too excited. The pre-1899 cutoff stands on its own merit. If the receiver was manufactured in 1898 or earlier, it qualifies as an antique regardless of whether it still fires a caliber you can walk into a store and buy today. The replica and muzzleloader carve-outs are separate categories with their own specific conditions. And the NFA, which governs things like short-barreled rifles and machine guns, also excludes antiques from its definition of firearms, so you're not accidentally wandering into restricted territory just because something is old. But here's the part people always forget. State law can be significantly stricter. Places like Illinois funnel everything through their FOID system. Some jurisdictions treat antiques almost identically to modern firearms when it comes to possession, carry, or transport. Federal green light does not automatically override your state's restrictions. So why do collectors and shooters care about this category? Because antiques can be bought, sold, and collected without the usual federal hurdles, and many of them are perfectly shootable with modern loads or black powder substitutes. For people who love history but still want trigger time, this is a legitimate and well-established lane. Now, this is where people really start getting confused, so pay close attention. Under federal law, muzzleloaders and percussion cap revolvers that fall within the antique firearm definition are not considered firearms for Gun Control Act purposes. The statute carves out three distinct buckets. First, anything made in or before 1898. Second, replicas not designed for rimfire or centerfire fixed ammunition, or that use obsolete and commercially unavailable cartridges. Third, muzzle-loading rifles, shotguns, and pistols designed to use black powder or black powder substitutes that cannot accept fixed ammunition. If a gun lives in any of those buckets, it's outside the GCA entirely. No Form 4473, no background check. The ATF has stated this in plain language. A muzzleloader meeting the antique definition is simply not a firearm under federal law. That's why you can order cap and ball revolvers and muzzleloaders shipped directly to your front door from major retailers without involving a dealer. But two critical caveats. First, state laws vary wildly. Some states treat cap and ball guns much closer to modern firearms for purchase and carry purposes, so you absolutely must verify your local regulations. Second, and this is where people get themselves into trouble, if you take a percussion revolver and install a cartridge conversion cylinder, you've just created something that accepts fixed ammunition. At that point, you've crossed the line into firearm territory under the GCA. Don't blur those categories. The distinction matters enormously. This one has changed dramatically in recent years, and if you're operating on information from even 2 or 3 years ago, you might be dangerously out of date. Under current rules, some unfinished frames, receivers, and weapon parts kits are treated as firearms, and some aren't. The dividing line comes down to how close they are to being functional. The ATF's 2022 frame and receiver rule introduced a readily convertible test with updated definitions. A partially machined blank or kit that can be turned into a working firearm with ordinary tools may now require serialization, a dealer transfer, and a background check. The Supreme Court reinforced this framework in the Bondi versus Vanderstock case, holding that at least some parts, kits, and unfinished frames do fall under the Gun Control Act. Those buy and build kits that used to ship like hobby projects are, in many cases, now regulated like completed firearms. So what still falls outside? A true receiver blank that remains solid in the fire control area and isn't bundled with jigs, drill bits, and near-complete parts can potentially remain outside the GCA. The ATF has long maintained that a raw chunk of material with no indexed or machined fire control cavity isn't a firearm by itself, but package that same blank with everything needed to finish it, and you've likely crossed the regulatory threshold. Building a firearm for personal use remains federally lawful if you're not a prohibited person and you're not doing it as a business. You don't need to engrave a serial number just because you own it. However, if that gun ever enters an FFL's inventory for consignment, repair, or sale, the dealer must mark it, and it must be detectable under federal law. Several states have gone further than the federal baseline and restrict or outright ban unserialized builds and parts kits. So know your jurisdiction before you click purchase. A lot of people don't realize this has been on the books for a very long time. Federal law permits you to manufacture your own firearm for personal use, whether you're assembling a rifle kit, building a shotgun from components, or machining a receiver from raw stock. The critical requirement is that it's for you, not for sale or distribution. But building your own doesn't exempt you from configuration rules. Step into NFA territory without the proper paperwork and tax stamp, and you've committed a federal crime. Rifle barrels must be at least 16 inches, shotgun barrels at least 18. Both require a minimum 26-inch overall length. Anything shorter without an approved Form 1 is an instant NFA violation, and those carry serious penalties. Your home built also has to be detectable under federal law, and if you're building certain semi-automatic configurations, you need to be aware of the imported parts, count restrictions under federal statute. It's not just about whether the gun functions, it's about what's in the parts mix. Here's where the rubber meets the road for most everyday gun owners. If two people who live in the same state want to conduct a private firearms transaction, federal law does not require them to use a dealer or run a background check. The seller simply cannot know or have reasonable cause to believe the buyer is a prohibited person. That's the federal standard. No FFL involvement required. But the moment you cross a state line, everything changes. A non-licensee cannot transfer a firearm directly to a resident of another state. That transaction must go through a federally licensed dealer in the recipient's home state. Parking lot deals with out-of-state plates are a hard no under federal law. Now, the question everyone asks is, how many guns can I sell before I need a license? There's no magic number. The test is intent. After the Bipartisan Safer Communities Act, the definition of being engaged in the business was tightened. If you're repeatedly selling firearms to earn a profit, you likely qualify as a dealer in the government's eyes, and you need a federal firearms license. Offloading pieces from a personal collection is one thing. Regular profit-driven sales are something else entirely. And once again, state law can layer on additional requirements. A growing number of states mandate that all private transfers go through a licensed dealer, effectively creating universal background checks at the state level, even though federal law hasn't imposed that nationwide. When a firearm passes through a will or through intestate succession, federal law treats that transfer differently from a standard sale. Two key exceptions apply. You can receive or transport an inherited firearm into your home state even if you obtained it in another state, and a non-licensee can transfer a firearm to an out-of-state heir to carry out the bequest, both without routing through a dealer. But inheriting a gun doesn't override personal disqualifications. If you're a prohibited person, or if your state bars that particular firearm, you cannot legally take possession regardless of what the will says. For NFA items like suppressors or short-barreled rifles that are lawfully registered, those transfer to a legal heir tax-free on an ATF Form 5, and the ATF permits direct interstate transfers to the beneficiary as long as the heir and their state law allow possession. One practical note: if an FFL handles the delivery for convenience or shipping purposes, that final handoff becomes a dealer disposition, which triggers the 4473 and background check even though federal law didn't require a dealer for the bequest itself. Let's close this out with the guns you actually see changing hands every single weekend. Surplus bolt-action rifles and rimfire workhorses. Most surplus military rifles qualify as curio and relic items because they're over 50 years old. But here's the important distinction. Curio and relic firearms are still firearms under the Gun Control Act. They're not antiques. They're treated like modern guns unless you hold a collector's license or go through a dealer. Where the no-dealer conversation applies is in same-state private sales. Federal law permits an unlicensed person to sell a firearm to another unlicensed resident of the same state, provided the seller has no reason to believe the buyer is prohibited. That's the lane where a surplus bolt gun at a gun show or a rimfire rifle from a friend's collection can change hands without a dealer in the middle. Cross a state line, and the deal must go through an FFL. No exceptions, no shortcuts. And as always, your state may impose stricter requirements that override the federal baseline. That's it for today, folks. See you in the next video.